judgment is expected in the murder case of the Alexandra resident Collins Khosa. The judgment is currently being handed down. Let's go there now live.
And it enshrines the rights of all people and affirms its democratic values of human dignity, equality and freedom, which must be respected, protected, promoted and fulfilled by the state and all organs of state. See sections 7 and 8 of Chapter 2 of the Constitution. The urgent application before me is of an unusual nature, inasmuch as, on a first reading, it only seeks me to restate the law. The law in this context would be the relevant provisions of the said Constitution, the Disaster Management Act 57 of 2002, international documents relevant in the context of Section 39, brackets 1, brackets small b of the Constitution, such as the Universal Declaration of Human Rights of 1948, the International Covenant on Civil and Political Rights of 1976, brackets, a treaty which South Africa has ratified and which is thus part of South African law, close brackets, the United Nations Convention Against Torture and other cruel, inhuman and degrading treatment or punishment of 1984, brackets, quote, Torture Convention, unquote, close brackets, which was also ratified and domesticated through the Prevention and Combating of Torture of Persons Act 13 of 2013, brackets, Torture Act, close brackets. And further, the domestic law, namely the South African Police Act 68 of 1995, the Defence Act 42 of 2002, the Criminal Procedure Act 51 of 1977, and Military Ombud Act 4 of 2012, as also the Independent Police Investigative Directorate Act 1 of 2011. The urgent application before me consists of some 1,300 pages, which were delivered to me in the afternoon of 2nd May 2020. The heads of argument of the parties, consisting of some 280 pages, were delivered to me during the late afternoon of Monday, the 4th of May 2020. The hearing was set down for Tuesday, the 5th of May, and continued on the 6th of May 2020. It is evident that this process is not the usual one, as envisaged by the rules of court relating to urgency, and the particular practice manual of this division pertaining to the same topic. I decided, however, to condone all non-compliance because of the nature of the application and the relief sought, which in my view all had to be considered carefully and properly and urgently in the context of the state of affairs that now exist under the Disaster Management Act of 2002, as well as the state of the South African economy, which existed immediately, but also for a fairly long period of time before the relevant decisions in terms of the Disaster Management Act were taken by the President, which provided for a, quote, lockdown, unquote, in terms of regulations that were published from time to time, as well as amended on occasions. In law, context is everything, and as will become apparent when I deal with a particular relief that was ultimately sought by the applicants, I have kept the context in mind, as it forms an important part of the applicant's case, as well as that of certain of the respondents. During the last year or so, international rating agencies classified the South African investment rating as being of, quote, junk, unquote, status, which of course had its own consequences on the financial markets, on the value of the rand, and the ability of the government to borrow money on international markets. Added to this, that was the fact that there is vast unemployment in South Africa, substantial inequality between various groups of our population, lack of basic facilities such as electricity and water, the supply of electricity, and very little foreign investment, which could have alleviated the situation. Coupled to that are the problems that have been grappled with for years relating to state-owned enterprises which by any definition were all insolvent and unable either to function properly or at all from time to time. All of this obviously had an effect on the mood of the nation, if I could call it that, and especially the youth, who were faced with limited employment opportunities and the lack of any hope to obtain a proper education. These are unfortunately the realities, and they play a role in this application if it is read properly as a whole. I must, however, add that this case is not concerned with the question whether or not any of the regulations promulgated are unlawful and thus invalid because they are not rationally related to their purpose, i.e., to contain the spread of the coronavirus. Rationality is part of the rule of law requirement. It is viewed objectively, and it is irrelevant that the decision was made mistakenly or in good faith. See Pharmaceutical Manufacturers Association of SA, in re ex parte President of the Republic of South Africa, 2000(2) SA 674(CC) at paragraph 20. A seemingly irrational regulation seems to be that one can purchase only certain items at a supermarket whilst not others. It makes no sense, and it affects economic progress that must go hand in hand with a concerted effort by all, including the citizenry, to contain the virus. It should not be a choice of either the public health or the state of the economy. It is necessary to safeguard both. The virus may well be contained, brackets, but not defeated until a vaccine is found, close brackets. But what is the point if the result of harsh enforcement measures is a famine, an economic wasteland, and the total loss of freedom, the right to dignity and the security of the person, and overall the maintenance of the rule of law? The answer, in my view, is, there is no point. However, I need to say something in the context of the present state of affairs and the application as a whole. The populace must be able to trust the government to abide by the rule of law and to make regulations that promote their stated purpose. These should intrude upon the rights of people, brackets, and businesses, either not at all, or if they do, or justifiably must, the least restrictive measures must be sought, applied, and communicated to the public. In return, the government can justifiably expect the citizens to cooperate for the common goal, take responsibility to ensure their own safety and that of others. The social contract that I've briefly referred to will then take its rightful constitutional place for the benefit of the nation and the state. If there is no such community of interest, the whole exercise and purpose of lockdown will fail, and a wasteland and social unrest awaits us all. The citizenry must also take responsibility to achieve the stated goal, even when they are exercising their rightful freedom of choice. Returning then from the duty of the population to the duty of the government, I must point out, as I will again hereunder, that the founding values of our Constitution include a democratic government based on the principles of accountability, responsiveness, and openness. The public administration, which includes all organs of state, must be accountable, and transparency must be fostered by providing the public with timely, accessible, accountable, and accurate information. See Section 195, brackets 1, brackets small g of the Constitution, and All Pay Consolidated Investment Holdings Pty Limited versus Chief Executive Officer, South African Social Security Agency and others, 2014, brackets 9 SA 179, brackets CC at paragraph 50. Thus, if the government is held to these constitutional obligations and the citizens' trust is restored and lawful, rational regulations are obeyed, the expected flood of litigation will retreat and the spread of the virus will be contained until the appropriate vaccine is found. The fact of the matter is simply the following: communality or failure. Geef me net 'n pen daar asseblief, ekskuus. No, just ask my secretary just to give me a pen, please. Excuse the interruption, I just had to fix something. That is the introduction to my judgment. I then dealt with the parties before court, and for present purposes, I want to continue with aspects relating to the hearing before me. I'm glad to say that the hearing was conducted in the most amiable manner, and every counsel conducted himself, herself, with the greatest degree of professionalism and dignity. I'm proud to say that the South African public, as well as the respondents, were well served by all counsel who appeared before me. The arguments were well prepared and to the point. Obviously, I, as judge, was obliged to put certain problems to counsel that I had with the relief sought, and these were promptly and properly addressed to such an extent that towards the end of the hearing, I was handed a draft order by the applicants, which in a number of material respects asked for lesser relief than that sought in the original notice of motion, and accordingly the last hours of argument concerned themselves with the relief sought in that particular manner. The Socioeconomic Rights Institute was admitted as an amicus curiae and supplied me with written heads of argument, which I undertook to consider for purposes of my judgment. No oral argument was necessary and was thus not delivered. The Fair and Equitable Society sought leave to intervene as an applicant, and after having listened to argument relating to urgency of the application and the nature of the interest that this applicant either had or did not have, I decided that it had no substantial interest in the application brought by the present applicants, and that the matter was not urgent in any event, because this party had waited about 1 month before it launched its application, obviously in the hope that it could ride on the back of the present applicants. There was no basis for this hope, and what was even more disturbing was that the particular members of the public who were said to have suffered at the hands of the SAPS and SANDF had all allegedly been either assaulted, shot, and even murdered by the Johannesburg Metropolitan Police Department during the first 10 days or so of April 2020. Despite that, it was common cause that no complaint had as yet been laid by these persons or by the society. In the light of those facts seen cumulatively, I struck the matter off the roll but made no cost order. This society has other remedies at its disposal, and obviously the first would be to register a complaint with the relevant authorities, to ensure that the complaints are properly investigated, and then, if necessary, to approach the court in its own right for an order that would be appropriate, having regard to the facts then at its disposal. As I have mentioned in my introductory paragraphs, an important factor arose during argument, and that is also contained in the affidavits when read together, is that I and counsel were at idem that at present there is a large measure of distrust between the South African populace and the government. This distrust relates primarily to the functions of the respondents and how they treat the persons throughout South Africa in the context of the regulations made under the Disaster Management Act. The fear of the population relates at present not only to the fear of contracting the virus, but also to the fear of what will happen after the national lockdown is called off. It is plainly clear, brackets, counsel in court admitted also that a judge is allowed to read newspapers to keep himself or herself informed of current events, close brackets. that the present lockdown measures will result in massive unemployment with all its consequences relating to the inability to provide each particular family with sustenance and an income. It is clear that thousands of small businesses have been adversely affected, and many of them will probably never be re-established. Unemployment will become worse, and many families, in fact most likely millions, will think about the future with a great deal of insecurity and despair. Added to that is that both the Commissioner of the South African Revenue Services and the Minister of Finance have told the public about the billions of rand that are lost every month, unrecoverable in my view, as a result of the lockdown regulations and the fact that thousands of businesses have ground to a halt. This, of course, has a snowball effect inasmuch as the state is deprived of revenue that it would receive by way of various forms of taxes. It is no exaggeration to say that the national psyche has thus been negatively affected by the lockdown regulations. How this will ever be rectified, nobody knows, and the public is not told. It was therefore my view, and Council accepted this as well, that the application should be seen in the context that I have referred to. I must emphasize that all Council were in agreement that a lockdown was necessary, and I must add that I am of the same view, lest there be any doubt about that. The public is, however, entitled to be treated with dignity and respect, whether rich or poor. Section 7 of the Bill of Rights makes this abundantly clear, and there is no doubt about that. They are also entitled to human dignity, and this right needs to be respected and protected, as again made abundantly clear by Section 10 of the Bill of Rights. Similarly, the public is entitled to the right of life by way of Section 11, and everyone has a right to freedom and security of the person according to the provisions of Section 12, which includes the right to be free of all forms of violence from either public or private sources, not to be tortured in any way, and not to be treated or punished in a cruel, inhuman, or degrading way. Section 12, brackets 2 provides that everyone has a right to bodily and psychological integrity, which includes the right to security in and control over their body. Section 21 deals with the right to basic education, and Section 31 entitles all members of the community to enjoy their culture, practice their religion, use their language, and to form, join, and maintain religious and linguistic associations and other organs of civil society. Section 35 deals with the rights of an arrested, detained, and accused person. An important section in the present context is Section 36, which deals with limitations of rights and states that the rights in the Bill of Rights may only be limited in terms of a law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account a number of factors, the most important of which, for present purposes, is the question whether or not the state has introduced less restrictive means to achieve the purpose of any particular regulation made in terms of the Management of Disaster Act, in brackets Section 36, brackets 1, brackets small e. Some of these rights, including the right to equality, human dignity, life, freedom or security of the person, and arrest and detained and accused persons, may not be derogated from, even in a state of emergency. All of these rights may be enforced by anyone acting in their own interest or acting on behalf of another who cannot act in their name, or acting as a member of or in the interest of group or class of persons, or acting in the public interest by approaching a competent court, alleging that a right in the Bill of Rights has been infringed or threatened, and the court may then grant appropriate relief, including a declaration of rights. Declaratory orders are discretionary and flexible, and all relevant circumstances must be considered. It is a flexible remedy which can assist in clarifying legal and constitutional obligations in a manner which promotes the protection and enforcement of the Constitution and its values. See Rail Commuters Action Group versus Transnet, trading as Metro Rail, 2005 brackets 2 SA 359, CC at paragraph 107. This court has given certain powers in constitutional matters, and when deciding such, Section 172 provides that the court must declare any law or conduct that is inconsistent with the Constitution to be invalid to the extent of its inconsistency, and make any order that is just and equitable. I will deal with this section again here under. The next chapter of my judgment deals with the relief sought, which I will not read out. And I then deal with the lockdown and the relevant statutes that apply to that, which I referred to in my introduction. I also referred to the fact that the President on 25 March declared the lockdown and how that was phrased and communicated. The next chapter of my judgment then deals with the torture and murder of Mr. Collins Khosa, which I have set down in some detail by a reference of what was contained in the founding affidavit. I then deal with the comment of certain ministers of the cabinet, which were made after the assaults on Mr. Khosa and others on that particular day, 10 April 2020, and how these annexes found their way into the affidavits. I then, as I've mentioned, deal with foreign law and then the local law, which deals with the limits of the use of force in terms of the Police Act, the Criminal Procedure Act, and the Defence Act. Then, as I've said, return to Section 38 of the Constitution, which grants the court the power to grant discretionary relief by way of a balancing process which must consider all relevant rights of all parties and all relevant circumstances. And that is the reason why I gave a fairly lengthy introductory comment. Obviously, these rights and the infringement of at present cannot be seen in a vacuum. I then dealt with Section 172 of the Constitution, which also obliges me to grant any conduct contrary to the Constitution as unlawful and invalid, and which provides that a court has very wide relief at its disposal, again considering what is appropriate having regard to the present facts. I then dealt with certain specific parts of the relief that was sought and gave my comments thereon. And I dealt with the question whether or not the South African Police Service and the Defence Force have sufficiently addressed the concerns raised in the application. It will be remembered that it was argued that both of these forces have documents in place which deal with the use of force, and have said in the answering affidavit that instructions are also given to the forces as to how to conduct themselves in the process of law enforcement and also under the Disaster Management Act. I'll then deal with the standards of international law, which I've mentioned, the role of the military ombud, against whom no relief was sought, but who provided affidavits, and then I deal with the specific prayers contained in the draft order that was handed to me, which I've analyzed in the context of all of the above legislation. After that, I come to my order. And before I read it out, there's one important paragraph that I was referred to by Applicants' Counsel, which appears in the Constitutional Court decision of Mohammed and another.
It's 12 o'clock Central African time on day 50 of the lockdown. We apologize for the loss of sound in those court proceedings. Judgment is being handed down in the matter of Khosa. Of course, we know it was an Alexandra man who was killed during the lockdown, and we're going to find out, the judge is going through how he's going to use international law and certain cases. Let's go back live to that.
It teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. My order then reads as follows. Paragraph 1. This application is heard as one of urgency in terms of Rule 6, brackets 12, the ordinary requirements of the rules in respect of notice, service and time periods being dispensed with, and the applicant's departure therefrom being condoned. Prayer 2, Order 2 rather. In terms of Section 38 and 1721B of the Constitution, read with Section 21(1)C of the Superior Court Act 10 of 2013, it is declared that during and notwithstanding the declaration of the state of disaster and the lockdown under the Disaster Management Act 57 of 2002, 2.1, all persons present within the territory of the Republic of South Africa are entitled to, brackets, amongst others, close brackets, the following rights, which are non-derogable even during states of emergency. 2.1.1, the right to human dignity. See Section 10 of the Constitution. 2.1.2, the right to life. Section 11 of the Constitution. 2.1.3, the right not to be tortured in any way. Section 12, brackets 1, brackets small d of the Constitution. 2.1.4, the right not to be treated and punished in a cruel, inhuman or degrading way. Section 12, brackets 1, brackets small e of the Constitution. 2.2. Under Section 195, brackets 5 of the Constitution, the South African Security Services, which include the South African National Defence Force, the South African Police Service, and any Metropolitan Police Department, must act and must instruct their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. 2.3. As organs of state, the 1st to 7th respondents, the SANDF and the SAPS, and any Metropolitan Police are obliged, under Section 7, brackets 2 of the Constitution, to respect, protect, promote and fulfill the rights in the Bill of Rights, including those enumerated above. 2.4. Members of the SANDF, the SAPS, and any MPD remain bound by Section 13, brackets 3, brackets small b of the South African Police Service Act 68 of 1995, read with Section 20, brackets 1, brackets small a of the Defence Act 42 of 2002 to use only the minimum force that is reasonable to perform an official duty. 2.5. Members of the SANDF, the SAPS and any MPD, as well as their commanders or superiors, including each of the 1st to 7th respondents, are bound by the provisions of the Prevention and Combating of Torture of Persons Act 13 of 2013 and the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment of 1984. Paragraph 3 of my order. The 1st to 4th respondents within the respective areas of authority shall 3.1. Within 5 days, pending the outcome of disciplinary proceedings, place on precautionary suspension on full pay all members of the SANDF who were present at or adjacent to 3885 Moketsi Street, Far East Bank, Alexandra, Johannesburg on 10 April 2020. 3.2. Within 2 days, command all members of the SANDF, SAPS, and any MPD to adhere to the absolute prohibition on torture and cruel and inhuman or degrading treatment or punishment, and to apply only the minimum force that is reasonable to enforce the law. 3.3. Within 5 days, warn all members of the SANDF, the SAPS, and any MPD, as well as their entire chain of command, that any failure to report, repress, or prevent acts of torture or cruel, inhuman, or degrading treatment or punishment shall expose them each individually to criminal, civil, and/or disciplinary sanctions. 3.4. Within 7 days, lodge affidavits with this court confirming that the above has been done. 3.5 of my order. It is recorded that the 6th respondent shall immediately commence a process to place the members of the JMPD who were present at or adjacent to 3885 Moketsi Street, Far East Bank, Alexandra, Johannesburg, on 10 April on suspension, pending an investigation into charges of misconduct. Paragraph 4 of the order. The 1st to 4th respondent shall, within 5 days, develop and publish a code of conduct and operational procedures regulating the members of the SANDF, SAPS, and MPDs in giving effect to the declaration of the state of disaster. 4.2. Widely publish the following in newspapers of national and provincial circulation, electronic platforms available to the government such as WhatsApp, Facebook, and Twitter, and national and provincial radio stations. 4.2.1. Guidelines about the circumstances when the use of force may be used in strict compliance with Section 49 of the Criminal Procedure Act. 4.2.2. Guidelines about the enforcement of the lockdown regulations and any other regulations issued during the state of disaster. 4.2.3. Guidelines about enforcing social distancing and the restriction of movement and other activities at each of the different stages of alert during the state of disaster. 4.2.4. Guidelines about when a person may be arrested and alternative means of securing their attendance at trial. 4.2.5. Information regarding where members of the public may lodge complaints against members of the SANDF, the SAPS, and other or any enforcement agency or officer. 4.3. Lodge affidavits with this court confirming that the above has been done. 5. The 1st to 6th respondent shall, within 5 days, establish a freely accessible mechanism for civilians to report allegations of torture or cruel, inhuman, or degrading treatment or punishment committed by members of the SANDF, the SAPS, or any MPD for the duration of state of disaster. 5.2. Widely publicize such mechanisms throughout South Africa via television, radio, and digital media in all 11 official languages. Paragraph 6 of my order. The first and fourth respondent shall ensure that the internal investigations into the incidents listed below are completed and reports are furnished to this court on or before June 2020. 6.1.1, the treatment of Mr. Collins Khosa. 6.1.2, the treatment of any other person whose rights may have been infringed during the state of disaster at the hands of members of the SANDF, the SAPS, and or any MPD. 6.2, immediately lodge each such report with this court. 6.3, furnish such reports to the applicant's legal representatives. 7, the ninth respondent is ordered to file its report of their investigations into this court by 22 May of this year. And 8, the first to fifth respondents shall jointly and severally bear the cost of this application, including the cost of 2 counsel. As far as costs are concerned, there is no reason why the applicants who were substantially successful should not be awarded such costs. I have a discretion in this regard, and their challenge was constitutionally justified and bona fide. That is the end of my order. Shall I? Luister net hier. Hier is 'n belangrike tikfout wat ek nou jullie pen voor gevra het. Dit is hier bladsy 7 voor jy iemand die uitspraak gee. Hierdie moet community of failure wees, nie community or failure. Thank you. That is my judgment, and thank you for your presence. Court adjourns.
Judge Hans Fabricius handing down judgment there in the matter of Khosa, the man who was killed allegedly by SANDF members.